Following the entry into force of the General Data Protection Regulation, the GDPR, WhatsApp users complained to the supervisory authorities of several member states that this undertaking was not complying with this regulation. The Irish Data Protection Commission, as the lead authority, then launched an investigation to assess whether WhatsApp was complying with its obligation, particularly with regard to transparency and information. The Data Protection Commission then sent a draft decision to the other national authorities concerned in order to gather their respective opinions. As no consensus could be reached, the Data Protection Commission referred the matter to the European Data Protection Board as provided for in the GDPR, for a ruling on the disputed points. The board issued a final and binding decision for all the authorities concerned, in which it found that certain provisions of the GDPR had been breached and required the Data Protection Commission to amend the proposed corrective measures, including the amount of the fines. On that basis, the Data Protection Commission issued its final decision, which was addressed to WhatsApp and imposed inter alia fines totaling 225 million euros. WhatsApp brought an action for annulment against the board's decision before the General Court of the European Union. However, the General Court dismissed the action as inadmissible on the grounds that the board's decision was not a challengeable act and that WhatsApp was not directly concerned by that decision. According to the General Court, the board's decision was only an intermediate measure and WhatsApp could only challenge the final decision of the Data Protection Commission before a national court. WhatsApp then appealed the General Court's order before the Court of Justice. In today's judgment, the court states first that the board's decision is indeed an act that can be challenged before the EU courts. That decision is binding on all the supervisory authorities concerned, which are third parties in relation to the board. Furthermore, it definitively establishes the position of that EU body and exhausts all the questions referred to it. Consequently, that decision can not be regarded as an intermediate measure which is not open to challenge. Secondly, the court finds that WhatsApp was directly concerned by that decision as it brought about a distinct change in its legal position of that undertaking without leaving any margin of discretion to its addressees. That decision is unconditionally binding on the supervisory authorities concerned, in particular as regards the finding of an infringement of certain provisions of the GDPR. And those authorities cannot alter its outcome. WhatsApp's action for annulment is therefore admissible, and the General Court's order is set aside. The Court of Justice refers the case back to the General Court for it to rule on the substance, including the question of whether WhatsApp infringed the relevant provisions of the GDPR.